So I've started recording. So it's a great pleasure for me to express the great happiness that you all joined us during this second meeting in the second series of contemporary challenges. And let me at first express my sincere gratitude to the speakers, to Ms. Katarzyna Celewicz, notary in Krakow, to Mr. Arthur Fuccillo, real estate lawyer from Lerner Enterprises, and Mr. Krzysztof Maj, notary from Krakow, being also currently in the Council of Kraków Chamber of Notaries, who used to be the president of the Kraków Chamber of Notaries. They all have generously agreed to devote their precious time to share with you some of their professional experience and to present them the way the lawyers in both Poland and the United States secure real estate transactions. I would also gladly thank Professor Ria Wortham, Professor Piotr Szwedo, Jagoda Szpak, who are the staff of the CUA and JU American Law Program, who generously supported me in designing, organizing, and advertising this event. So just to make it quickly, the format of this meeting: firstly, each of the speakers will present herself or himself and contribute with her or his presentation on the webinar topic. Then we would welcome your questions and comments that should be written on the chat. I will read them to the presenters, and then they will respond. This first hour of webinar will be recorded. Later, we may still stay for like half an hour, and then the non-recorded part will follow. That will allow for a real discussion. Then you can ask your questions and comment and present your comments yourself. This webinar series is a second series of events. We used to do it in 2021, 2022, in 2020, 2021, when we canceled the American Law Program because of COVID pandemic. And then we took the occasion to somehow replace it for a year with a series of webinars, with a very successful series, 16 events that used to gather more than 130 participants per meeting. I'm just admitting another participant still. So the idea was that it will substitute the American Law Program taking place at the Jagiellonian University with the kind participation of the Catholic University of America professors. We normally come to Krakow and teach 12-week-long courses in different nuances of American law. I just mentioned it briefly for you to know the context of this series of meetings, and also be conscious that participation in 5 out of 7 webinars allow to be admitted to the American Law Program without the entrance exam. The recruitment for the 2021 to 2023 American Law Program is still open right now. So I hope that you will enjoy this webinar and also enjoy all other formats in which Catholic University of America in Washington, D.C. and the Jagiellonian University in Krakow fruitfully cooperate for more than 30 years. And I look forward to see you and to today's discussion. So at first, I would gladly welcome Ms. Katarzyna Celewicz, who will say a few words about the notary profession in Poland.
Good day. My name is Katarzyna Celewicz. I'm a notary since 2013, admitted to Kraków Chamber of Notaries. I have like regular educational path I have. In 2006, I received law degree from the Jagiellonian University in Kraków. After passing the entrance test, I took notary apprenticeship that combines coursework specific to the notary profession functions, as well as internships in court and notarial office. Then I became notary substitute for 2 years, meaning working as a notary, but under supervision of other notary. Then after review and appointment, I became notary. I'm also Catholic University of America LL.M 2020 graduate. I was participant of program in Washington, DC in 2019. In 2020, I took legal drafting contracts summer course at Catholic University of America. So there was, during my stay in US, there was a question to explain who is notary. So generally, notary, according to real estate, is a lawyer who drafts agreement and other legal documents. So notarial form, notary agreement is obligatory for real estate transfer in Poland. Of course, during more complex transactions, the clients may be accompanied by attorneys, like real estate lawyers. Notaries do not represent individual clients in the matter, but rather are bound to draft documents that represent the understanding of all parties. Notaries are legally and ethically obliged to impartially and independently apprise and advise parties, for instance, on real estate matters. And the notary records transactions in land and mortgage in the state register. Then the other function of notary is that the notary collects transactional taxes. Notaries as well apply anti-money laundering proceeding, and notaries reports transactions to proper authority. So I would say that notary performs a public function, some of which would be done by public entities in US. But the notary is independent of the executive branch of government, but within the judiciary authority. What are basic securities of how notaries secure basic interest of clients? So first of all, notaries obliged to protect the legitimate interests of the parties. So by providing expert counsel, by helping to securing payments according to real estate transfers. Usually notarial act has clause that is enforceable title for debt collections. They also secure mortgage payments by establishing mortgages. And the other thing is that notary is legally liable if their clients suffer damage as a result of the negligence. So I think it's some kind of warranty. As well, notary secure interests of state. So by collecting taxes, by applying anti-money laundering proceedings, and administering preemptive rights for governmental agencies, because some transfer of real estate are secured by real governmental agencies as preemptive rights, like agricultural real estate or forests. So National Forest Agency can buy out the property. Notary, I would like to say as well that notary does not act as real estate lawyer, because notary does not represent party. Notary doesn't have time to spend long hours with clients to negotiate contracts. And from my US experience, I could see that in continental law, where we have civil codes, when we have statutes, it's I would say it's easier to draft contract, because if we don't write something in the contracts, there is law that we can apply, and there is no such a big there is some kind of certainty about the law that we can apply. Yes, so that would be my presentation about notaries in Poland and in continental law system.
Oh, thank you very much. So now I think I will ask Mr. Maj to continue with the profession of a Polish lawyer, Polish notary, and after that we will have Mr. Fuccillo, who will, Fuccillo, do I spell it right?
Yeah, you've done very well so far, yes. Either
Okay.
way, Fuccillo or Fuccillo in Italian, thank you.
Okay, so thank you very much. And then we will follow with your presentation. So Mr. Maj will present it in Polish, and I will make translation.
Dzień dobry Państwu, Krzysztof Maj z tej strony. Jestem notariuszem w Krakowie od 2000 roku. Natomiast wcześniej rozpocząłem przygodę z notariatem od 1994 roku.
Ladies and gentlemen, my name is Krzysztof Maj. I'm a notary from Krakow. I used to be a notary from year 2000, but I started my career with the notary chamber and notary profession already from 1994.
Od 2012 roku do 2018 roku byłem prezesem Rady Izby Notarialnej w Krakowie. Od 2018 roku do dnia dzisiejszego jestem członkiem Rady Izby Notarialnej w Krakowie.
From 2012 up to 2018, I used to be the president of the Kraków Chamber of Notaries. From 2018 until now, I'm the member of the council of the chamber.
Proszę Państwa, w nawiązaniu do tego, co powiedziała pani Katarzyna Celewicz, ja chciałbym tutaj uczestnikom amerykańskim jak gdyby pokazać pewne 4 rzeczy, które w bardzo istotny sposób być może zdefiniują obrót nieruchomościami i rolę notariusza w Polsce.
So following the presentation made by Ms. Katarzyna Celewicz, and somehow also directing this presentation to our American participants, I would like to underline 4 main issues that define the securities and the way the real estate transfers in Poland are created and protected.
Po pierwsze, musimy sobie odpowiedzieć na pytanie, co oznacza obrót nieruchomościami. To jest pewnego rodzaju skrót myślowy, gdzie mówimy, że przedmiotem obrotu jest przeniesienie własności nieruchomości.
First, we need to define the term of real estate exchange, real estate turnover. That's a kind of abbreviation for the discussion on what is really the transfer of real estate.
Co oznacza, proszę Państwa, że trzeba mieć świadomość taką, że w Polsce w tradycji między innymi prawa rzymskiego obowiązuje jednolite pojęcie prawa własności. Nie wiem, czy tak jest w Stanach Zjednoczonych.
So in Poland, following the tradition of Roman law, there is a single notion of ownership. That is, as I believe, not true in the American jurisdiction.
Oczywiście zostawiamy tutaj na boku inne szeroko rozumiane pojęcia dotyczące obrotu nieruchomościami, jak ustanawianie użytkowania, jak ustanawianie służebności, jak ustanawianie hipoteki. Na chwilę skupmy się tylko na własności.
We put aside other terms and rights that are connected with real estates, such as servitudes, usufructs, or mortgages. We will only focus on ownership.
Na czym polega, proszę Państwa, własność? Klasycznie to jest pewna triada uprawnień. Własność jest to najszersze prawo do nieruchomości, które obejmuje prawo posiadania rzeczy, pobierania pożytków i rozporządzania, czyli sprzedaży, zamiany, darowizny.
So at first, ownership. Typically, ownership contains three fundamental rights. It's the broadest right that a man can have regarding the thing, and it entails the right to possess thing, the right to obtain the fruits of the thing, and also the right to dispose of it by means of sale or donation.
I trzeba mieć tutaj świadomość taką, że niezależnie kto jest podmiotem prawa własności, ma co do zasady te same uprawnienia. Czy to jest osoba fizyczna, czy to jest spółka, czy to jest gmina, czy to jest Skarb Państwa.
Independently on who is the current owner of the thing, whether it's a private person, whether it's a company, whether it's the treasury or the municipality, the rights that such an owner has are the same.
Skoro mamy jednolite i uniwersalne prawo własności, a ustawodawca już 90 lat temu, bo mniej więcej lata 30. XX wieku, po odzyskaniu przez Polskę niepodległości, to jest wprowadzenie pewnej obowiązkowej formy przeniesienia własności nieruchomości. To jest forma aktu notarialnego.
It's been for 90 years in Poland because it was already in the interwar period that our legislator made a single unequivocal form to transfer ownership of real estate, namely by means of form of Notary Act.
Czyli skoro mamy jednolite, uniwersalne pojęcie prawa własności, to mamy też jednolitą i uniwersalną formę przeniesienia własności, formę aktu notarialnego, która, tak jak pani Celewicz powiedziała, jest obligatoryjna.
Then we have one single ownership right and one single form which is used to transfer such ownership. Then, as Ms. Celewicz already said, we have there's an obligation that we use the Notary Act form.
Oczywiście, tu trzeba poczynić jedno ważne zastrzeżenie, które polega na tym, że jeżeli mówimy o obligatoryjnej formie aktu notarialnego, dotyczy to obrotu cywilnoprawnego, czyli gdzie strony są równorzędne.
When we think about Notary Act form, we say only about the private law, civil law turnover exchange, where the two parties of the legal relation are equal.
Ponieważ jeżeli strony nie są równe, czyli mamy do czynienia z prawem administracyjnym, czyli państwo może na przykład wywłaszczyć prywatnego właściciela, może mu na podstawie aktu administracyjnego zabrać własność, ale nie mówimy wtedy, że jest to forma aktu notarialnego, to nie jest prawo cywilne, wchodzimy w regulację prawa administracyjnego, o którym nie chcę tutaj wspominać.
Certainly, when administrative law is involved, and then there is another kind of relation. Then there is some kind of superiority of the state over the participants of the exchange. Like in administrative law, there is a possibility that the state deprives the owner of ownership by means of expropriation. But then that's something different. Then it may take place not in the form of Notary Act, but by means of this administrative decision. But it is not something I would like to cover right now. I would focus on civil law, private law discussion right now.
I teraz tak, skoro mamy jednolite, uniwersalne prawo własności, jednolitą formę aktu notarialnego, to tutaj znowu trzeba zwrócić uwagę, podobnie jak przy prawie własności. Czy Jan Kowalski sprzedaje Iksińskiemu, czy Jan Kowalski sprzedaje gminie, w której mieszka, czy Jan Kowalski sprzedaje spółce, czy Skarb Państwa, czyli państwo sprzedaje komukolwiek, zawsze jest wymagana forma aktu notarialnego. Państwo ani podmioty publiczne nie są tutaj w żaden sposób uprzywilejowane.
The state is in no way privileged with the form of Notary Act. It doesn't matter whether John Smith sells the real estate to Adam Johnson or to a company or to the municipality, or maybe if the treasury sells the estate to whoever of them, then there is still the same form of Notary Act necessary.
I teraz przechodzimy do trzeciej sprawy. Skoro mamy jednolite prawo własności, jednolitą formę aktu notarialnego, to mamy jednolity podmiot, który jest uprawniony i obowiązany do dokonywania czynności notarialnych związanych z sporządzeniem aktu notarialnego. Tylko notariusz ma i prawo, i obowiązek sporządzania aktów notarialnych.
Following the single ownership and then single form of Notary Act, we also have a single profession that has both rights and duties in order to secure those transactions. Only the notary can proceed notary acts.
Jeżeli mówiłem o tym, że jeżeli gmina albo państwo chce sprzedać, to i czasami wójt, burmistrz, prezydent miasta albo nawet minister w imieniu Skarbu Państwa też musi się pojawić u notariusza, jeśli gmina lub Skarb Państwa chce sprzedać nieruchomość.
Well, even if the municipality or the treasury want to sell a real estate, then the town mayor, maybe the ministry in favor of acting as the state treasury will have to attend the meeting with the notary, and then with the form of Notary Act, transfer the ownership of the municipal or state real estate.
No ale kim jest ten notariusz? Notariusz jest taką dziwną hybrydą, dziwną istotą, dlatego że z jednej strony jest nazywany osobą zaufania publicznego, jest powoływany przez ministra sprawiedliwości, czyli tutaj istnieje funkcja publiczna po stronie notariusza. Z drugiej strony dokonuje czynności na własny rachunek ekonomiczny jako przedsiębiorca, czyli wynagrodzenie, które pobiera, musi mu wystarczyć na wszystkie koszty prowadzenia działalności pracowników i ewentualnie zapewnić mu utrzymanie.
So then the function of a notary is somehow hybrid, because from one perspective, he's a representative of the public authorities. He's supposed to be the person of public trust. But on the other hand, he's an entrepreneur, and drafting legal acts must be sufficient for him, and getting the salary, the fee for the notary acts must be enough for him to pay for the living and also to cover all the expenses of his economic activity, employees and...
Tak jak wspomniała już pani Celewicz, najważniejszym naszym zadaniem jest bezstronność. My jesteśmy prawnikami, owszem, ale reprezentujemy zawsze obie strony czynności, żadnej nie możemy faworyzować, interesy każdej musimy wyważyć, nie możemy zdecydować za strony, co mają zrobić, ale na miarę naszych możliwości powinniśmy pouczyć je o skutkach czynności, którą chcą zrobić.
We are not representatives of any parts. We cannot favor any of them. We are the representative of both parties. We cannot really fully advise them what to do, but we have to, at least in some extent, present them, show them the legal consequences of the legal act that they are undertaking and protect their interests.
Przykładowo, jeżeli ktoś chce sprzedać, przenieść własność dzisiaj już w tym momencie, a kupujący mówi, ja ci zapłacę za miesiąc albo za pół roku, to ja jako notariusz powinienem pouczyć tego sprzedającego, że powinien zabezpieczyć wykonanie tego zobowiązania o zapłatę. To jest jego decyzja, czy on będzie chciał hipotekę, czy on będzie chciał weksel, czy będzie chciał poręczenie, czy jakieś inne zabezpieczenie, ale ja powinienem mu na to zwrócić uwagę.
If someone wants to sell the estate right now, but the buyer may only pay the price in 6 months, then I have to tell the seller that maybe some kind of security will be needed to protect his interests. Maybe a mortgage, or maybe some other way to protect the payment of the price might be needed. It's his personal decision. It's the personal decision of the seller whether he wants it. But I need to tell him that he should take care of his interests.
Oczywiście każda ze stron aktu notarialnego, i sprzedający, i kupujący, może występować ze swoim adwokatem, który chroni interesy tylko tej jednej strony. Ale ja mam obowiązek wyważyć interesy obu stron i gdyby następowała znacząca przewaga jednej ze stron, powinienem drugiej zwrócić uwagę, że coś jest tutaj dla niej niekorzystne.
Certainly, any of the parties in front of drafting in the course of drafting the Notary Act may have their own lawyers who represent their interests, but I have to represent the interests of both of them. And if I see that there's a big, I have to balance those interests. And if I see that there's a huge discrepancy of the negotiational power of each of the party, I should point it out that something is wrong with this transaction.
Dlatego nie bez kozery notariusza nazywa się również sędzią braku sporu, czyli jest tak jak sędzia bezstronny, ma pewną władzę, ale wszędzie tam, gdzie nie ma sporu. Sędzia w sądzie cywilnym, w sądzie karnym ma tą władzę dyskrecjonalną, rozstrzyga. Ja też rozstrzygam, ale tam, gdzie nie ma sporu.
That's why sometimes notaries are named judges without a conflict. So notaries too somehow adjudicate, but only those situations in which there is no conflict between the parties. There is an adjudicational power on their side. Judges have this power when there is a conflict, and then they can choose whichever party they are in favor. Notaries choose the aim of both parties.
Tutaj trzeba jeszcze powiedzieć, że pewna specyfika działalności notariusza polega na tym, o czym również mówiła pani Katarzyna Celewicz, że notariusz jest płatnikiem danin publicznych, czyli jeżeli trzeba z tytułu kontraktu, umowy sprzedaży zapłacić jakiś podatek, jeżeli trzeba pobrać opłatę sądową za wpisy w księgach wieczystych, o których za chwilę będę mówił, notariusz jest obowiązany pobrać to od stron i przelać na rzecz Skarbu Państwa bądź sądu.
It's also important what Ms. Celewicz underlined is that notary also takes the public fees that are due from the transactions and then transfer such fees, for example, for the entry in the court register or for the taxes that are due for the transaction and transfer it to the relevant authorities.
Czyli proszę Państwa, mieliśmy jednolite prawo własności, mieliśmy jednolitą formę aktu notarialnego, mieliśmy jeden podmiot, czyli mamy jeden podmiot, który jest do tego uprawniony i obowiązany, ponieważ ja nie mogę powiedzieć, że Kowalski mi się nie podoba. Jak czynność jest zgodna z prawem, ja muszę dokonać tego aktu notarialnego. Czyli nie tylko mam prawo, ale i obowiązek. I z tym jest powiązany rejestr publiczny praw do nieruchomości, przede wszystkim własności, który się nazywa księgi wieczyste.
So we discussed three main issues, and then we have the fourth issue that shows the structure of property transfer in Poland. So we had single ownership, single form of notary act, single notary profession, and also single register that is involved.
Księgi wieczyste to jest takie założenie, że prowadzi się jawny dla wszystkich rejestr publiczny, gdzie każda nieruchomość powinna mieć ujawniony swój stan prawny, czyli kto jest właścicielem, jaka jest powierzchnia tej nieruchomości, czy są jakieś obciążenia, jakieś hipoteki, jakiej służebności, jakieś prawo użytkowania.
Land Mortgage Register is public, is available to everyone who may check the legal status of the estate, may get to know what's the physical status of the property, what's the surface, what's the size of it, but also just who is the owner, what are rights involved with this real estate.
Księgi wieczyste mają pewną istotną rolę, która polega na tym, że jest domniemanie tego, że to, co jest w księgach wieczystych, jest zgodne z prawdą.
An important function of the Land and Mortgage Register is the presumption that what is written in them is true and is legally binding.
Ja jako notariusz mam obowiązek, jeżeli dokumentuję transfer, przeniesienie własności nieruchomości, skierować do właściwego sądu. Nieważne, że jestem notariuszem w Krakowie. Jak mam nieruchomość z drugiego końca Polski, ze Szczecina, kieruję za pomocą podpisu elektronicznego błyskawicznie w ciągu kilku minut wniosek do właściwego sądu o wpis nowego właściciela do księgi wieczystej.
Even if I make draft a legal act that concerns the real estate in another part of Poland, I have a duty to make such a court in which the real estate is registered, a notice that I made a transfer of the legal estate. So right now I do it electronically with electronic signature, and just a few minutes after the legal act is finalized, there is a petition filed for entry of ownership following the legal act.
I to są takie właściwie 4 podstawowe elementy, w wielkim skrócie oczywiście, o których można tutaj powiedzieć. I teraz chciałbym się z Państwem podzielić własnymi doświadczeniami, które dotyczą styku, obrotu pomiędzy Stanami Zjednoczonymi a Polską. Po pierwsze, 10 lat temu, 12 lat temu, kiedy była deregulacja, czyli takie ułatwienie dostępu do zawodu notariusza, trochę dowiedzieliśmy się, jak to wygląda w Stanach. Mieliśmy nawet jako Izba Notarialna wykłady na ten temat i ja zapamiętałem, proszę mi wybaczyć moich tutaj amerykańskich rozmówców, nie wiem, czy we wszystkich Stanach tak jest, że w Stanach ważny jest tytuł i ubezpieczenie, czyli czy masz dobry tytuł, czy masz zły tytuł. Nie wiem, czy to są jakieś zaszłości historyczne, nie wiem, czy są rejestry prowadzone, nie wiem, czy to wynika z tego, że Stany Zjednoczone są kilkudziesięciokrotnie większe niż Polska. Nie wiem, czy tak jest nadal, ale to polegało na tym, że badamy twój tytuł, pytanie, kto badał ten tytuł i ewentualnie ubezpieczamy twój tytuł. Więc to jest taka moja wiedza, tutaj też do współprowadzącego pana Fuccillo, ewentualnie pytanie, żeby mógł powiedzieć, czy ja się tutaj mylę, czy mówię pewnymi skrótami myślowymi, czy tak jest nadal.
So what I wanted to present as first was those 4 pillars that are important in Polish law. And right now I would like to share some of my experience regarding the Polish and American legally change, and also some kind of comparative perspective that I used to be involved with. 10 or 12 years ago, when there was an idea to deregulate the notary profession, I had a series of meetings with American lawyers, we had a series of lectures concerning how they perceived the real estate transfer and its security. So then what I recall, and which maybe is not true, and maybe I will remember it badly, but what was important for the real estate transaction was a title, whether someone had a good title to the estate. I don't know who really analyzed it, but that was the issue, one issue. And the second issue was who ensures that the title is proper.
To jest jak gdyby jedna rzecz. Druga rzecz, jeżeli chodzi o kwestię notariusza, to w praktyce naszej spotykamy się z poświadczeniem podpisów przez notary public w Stanach Zjednoczonych, najczęściej na pełnomocnictwach, czyli obywatele polscy, którzy wyjechali do Stanów Zjednoczonych, a zostawili nieruchomości w Polsce albo odziedziczyli nieruchomości w Polsce, nie mogą przyjechać, udzielają najczęściej pełnomocnictw w Stanach Zjednoczonych i to czasami zaczyna stanowić pewnego rodzaju problem dotyczący w obrocie nieruchomościami. Zaraz wyjaśnię dlaczego.
Sometimes I meet the American law problems when it comes to the activity of notary publics who acknowledge the signatures mostly on powers of attorney. Usually they are drafted by Polish citizens who used to emigrate to United States, and then they had left some real estate in Poland, and they are not able to administer or to dispose of it in person, and that's why they draft such kind of powers of attorney with the help of notary public in the United States.
Zasada polskiego prawa międzynarodowego mówi tak, że pełnomocnictwo do przeniesienia własności nieruchomości jeżeli jest sporządzane za granicą, powinno być sporządzone w formie aktu notarialnego. A jeśli ta forma nie jest w danym kraju znana, tak jak w Stanach Zjednoczonych, powinno być udzielone w takiej formie, jakie jest właściwe w danym miejscu. Czyli jeżeli jest udzielane w Chicago, to w formie takiej, jaka jest właściwa do przeniesienia własności w Chicago. Jak na Florydzie, to według prawa właściwego dla stanu Floryda. Jeżeli to jest Omaha w stanie Nebraska, no to według prawa właściwego dla stanu Nebraska.
So, according to Polish international private law, then there is a demand that the power of attorney to transfer real estate must be either in the form of the Notary Act, and if such a form doesn't exist in a given jurisdiction, it must meet the form demand of the place where the power of attorney is drafted. So if it's drafted in Illinois, then it should have the form which is necessary in the state of Illinois for the power of attorney to transfer ownership of real estate. If it's Omaha in Nebraska, then it should meet the legal demand for power of attorney in Nebraska.
I tutaj muszę powiedzieć, że w naszej praktyce notarialnej polskiej zaczynają się pojawiać problemy, bo macie Państwo kilkadziesiąt stanów. W każdym stanów jest inne prawo, albo trochę różniące się, albo znacznie, bo oprócz większości chyba stanów, które przejęły tradycję prawa anglosaskiego, no są też takie chyba jak Luizjana, gdzie mamy te silne związki jeszcze z prawem kontynentalnym. W związku z tym mamy czasami problem, jak ustalić, jaka jest forma właściwa do przeniesienia własności nieruchomości, w szczególności w dostępnych w internecie tekstach aktów prawnych pojawiają się tak zwani świadkowie pełnomocnictwa. I tu też może pytanie do pana Fuccillo, czy rzeczywiście ci świadkowie są konieczni przy udzielaniu pełnomocnictwa w Stanach Zjednoczonych do przeniesienia własności nieruchomości, czy to wynika z jakiegoś niezrozumienia treści tych przepisów amerykańskich?
So it's quite difficult for Polish notaries to get to know what's really the form of transfer of estate or form of power of attorney in different states. We have more than 50 such states, of which are very different when it comes to the shape of real estate law. So we have those, basically most of them, derived from the Anglo-Saxon law, and but some of them, like Louisiana, for example, they follow the continental European legal system. So this is pretty complicated. Quite often, the participation of witnesses is involved, and it's very difficult for a Polish lawyer to establish what's really the function of such witnesses, whether they meet any kind of important, vital demand for the power of attorney, or is it some other tradition that is maybe hard to understand by Polish notaries.
I ostatnia sprawa, bo i tak się tutaj bardzo rozgadałem, że tak powiem, to jest sprawa dotycząca możliwości zawarcia w Stanach Zjednoczonych umowy pomiędzy stronami, która by dotyczyła przeniesienia własności nieruchomości w Polsce. Co do zasady, u nas Sąd Najwyższy, tutaj w pewnym skrócie mówię, takiej możliwości nie dopuszcza. I ja też się, proszę Państwa, czasami spotykam z sytuacjami poświadczenia podpisu na różnych formularzach sądowych, gdzie obywatele Stanów Zjednoczonych przebywający w Polsce składają podpisy na dokumentach dotyczących, że wyrażają zgodę tam na przeniesienie własności nieruchomości w Stanach, w szczególności jak to jest związane z jakąś sprawą rozwodową. Ale ja też stronom zawsze mówię, że ja nie wiem, czy to osiągnie skutek w Stanach, bo ja nie wiem, czy władze Stanów Zjednoczonych uznają moją jurysdykcję, czy ona jest właściwa, czy to jest właściwa forma. Więc to jest taki kolejny element z praktyki, którym mogę się podzielić i nie wiem też, czy prawo Stanów Zjednoczonych przywiązuje do tego jakąś szczególną formę, gdzie ma być dokonana czynność dotycząca przeniesienia własności nieruchomości, czy to poświadczenie podpisu na tym formularzu, ugodzie sądowej, bo to najczęściej są tego typu rzeczy, może się odbyć również w Polsce. No i tu też, gdyby uzyskać jakąś odpowiedź, stanowisko, to byłbym bardzo zobowiązany.
The third issue is to what extent the real estate transfers may take place in other jurisdiction. So parties quite often want to do this, and they perform it in different kind of court settlements, quite often connected with divorce issue, but they transfer the estate in some other country. Like in Poland, in Polish acts, they do it with regard to the American estates and the other way around. I'm usually very hesitant whether it can make any legal effect in the other country. To what extent the jurisdiction of lawyer in one state is capable of performing legal acts in another states with regard to real estate. And also I would gladly hear your opinion about the effectiveness of such transfers, for example, in Polish notary acts with regard to American estates.
Tyle, proszę Państwa, z mojej strony. Bardzo uprzejmie dziękuję i muszę tutaj powiedzieć, że ta inicjatywa jest w mojej ocenie tutaj bardzo cenna, żeby próbować poznawać różne systemy. Dzięki temu trochę łatwiej może zrozumiemy ten zglobalizowany świat, który niby jest bardzo daleko, ale czasami w naszej praktyce prawniczej okazuje się być bardzo bliskim.
Thank you. That's all from my side. Thank you very much for this initiative, which I really like and which I find very interesting, especially from the perspective that the two legal orders, two states, which seem to be very far away, but in our legal practice, they can be pretty close and come up to one another. So thank you very much. And also from my side, thank you very much, Mr. Maj, for your great presentation. And now I would like to hear from Mr. Fuccillo the presentation about the real estate lawyer profession, somehow in comparison with the Polish notary, but also we are just very eager to hear how is it like in the United States with regard to real estate.
Thank you. Thank you very much. My name is Art Fuccillo, and I live just outside of Washington, D.C., in a town called Rockville, Maryland, if you'd like to look it up. I have practiced law for over 40 years and predominantly made my career in real estate law. That gives everyone here on the Zoom call an opportunity to ask me any question you would like about American real estate law, and hopefully I can answer it. I started out in my profession after going to law school at Catholic University for 3 years. I went on for another 2.5 years and got my master's, received my master's in tax law from Georgetown University Law Center in Washington, D.C. I had attended college in Philadelphia at Villanova University. I went on to Catholic University for law school and then on to Georgetown for my master's, as I said, in tax law. I started out practicing in a law firm just outside of Washington, D.C., and specializing in real estate and construction. And in 1980, left the practice of law with the law firm and went in-house as counsel for a shopping center developer in Maryland, state of Maryland. And later on moved to another shopping center developer and real estate developer in Maryland by the name of Lerner. And hence I've been here for over 40 years at Lerner Enterprises. If you're a fan of American baseball, that's the family that owns the Washington Nationals baseball team in Washington, D.C. As I said, I've been practicing real estate for over 40 years. So let me walk you through a real estate transaction, and then hopefully that will spark some questions as to anything you might have that you'd like to know about real estate. And then I'll try to contrast it to what's been presented to you before relative to notaries in Poland. Our real estate transaction is predominantly across, let's say, 3 or 4 different sectors. You have residential, this purchase of a home as between 2 individuals generally. You have commercial, which is the purchase of an office building or a shopping center or a hotel or an industrial building as between individuals or companies. Then you might have a long-term lease on a building, whether it's the tenant who's leasing something or someone's leasing ground for a long time under a ground lease. It generally happens that the amount of effort that's put into each of those transactions may vary. In America today, on the purchase of a home, a residential home in a city like Rockville, where I live, it is not likely that there's going to be an attorney involved. The attorney really may have helped draft the original documents that are now become forms that are used by people, but local real estate agents will take those forms and help the parties negotiate to a contract, and then the contract will then proceed to closing eventually with a title company and an escrow agent, and no lawyer will be involved. As that is generally the case now in America, is that lawyers have done less and less residential drafting of contracts and less actual work involved in residential, only because the forms have developed. Now, let me draw some distinctions. You operate under a code-based system. We operate generally under the common law, except for Louisiana that was mentioned, which is French civil code. We don't have elements of real estate transactions codified in our laws. We may have certain provisions like the statute of frauds on the enforceability or basic elements, but none of the particular elements of a contract are anywhere in our codes. They're left to negotiation as between the parties. In America, when you go to law school, you generally graduate with a degree. You then take a test, which is known as a bar exam, and you take that test for the state in which you're going to operate. For example, I took the Virginia State Bar exam when I graduated law school, and I was licensed to practice in the state of Virginia. If I was licensed to practice in the state of Virginia, not having taken the New York bar exam, I was not licensed to practice in New York or Florida or West Virginia or Illinois or California, because I had not taken that state's bar exam. After I received my Virginia state license, I went and received my Maryland state's license. So I was licensed in both Virginia and the state of Maryland to practice law. I then became licensed in the District of Columbia. So at this moment, I'm licensed in 3 different jurisdictions: Virginia, District of Columbia, and Maryland. I'm not licensed in Florida. I'm not licensed in Georgia. I'm not licensed in Texas. So if I were to go there and practice law, I would really be committing breaking the law due to the unauthorized practice of law in the jurisdiction. So I stay within my jurisdiction. If I need something, I consult with an attorney who's licensed to practice in one of those jurisdictions. I mention that because within my world here, when I'm an attorney in Maryland or an attorney in Virginia, it gives me the right to go to court and be an advocate. It gives me a right to negotiate contracts. It gives me a right to give legal advice across a whole sphere of areas, because that's the training that I've been given and the generalized nature. Now, some of us may specialize. I specialized in real estate. Others may specialize in riparian or water rights. Others may specify in government contracts. Others may specify in lease administration or civil litigation or criminal procedure or criminal litigation or appeals. Lawyers then tend to specify, become more specific and specialize as they get into their practice. I raise that because in my mind, there really is no comparative position for the notary the civil notaries that you are, and the profession that you've studied in America. Now, let me come back to that in a second. Let me explain a real estate transaction as I would do it. in a real estate transaction that I would be involved in over the last several, decades, it would start with a perceived transaction between two parties. Now, those two parties may have been brought together by two real estate brokers, people who have a profession of finding land and finding opportunities for their buyer or selling it for their seller. And those two brokers would have respective clients, and those brokers would bring those clients together and say, I'm interested in buying your property. Thank you. I'm interested in selling. And they would draft a letter of intent. And that letter of intent is just simply what it sounds like. It's a letter as between the parties that is non-binding. It just basically sets forth the terms and conditions upon which a contract could then be drafted. That letter of intent may or may not be signed, but if it's signed, it's still not legally binding because it's not a contract. That letter of intent would then go, and both sides generally would be represented by counsel, where you're not representing someone and you have to act impartially. The advocates or the two attorneys that are retained are completely representing their clients and completely partial desires of their clients. Those two attorneys will then share a document that's a private document that one of them would have put together and sent to the other. It's not a public document, it's not a form. It can be made up, it can be short, it can be long, it can be whatever it wants. But whatever the terms and conditions are that they want to have in that contract have to be in that contract. There's nothing to go to. There's no civil code. There's nothing they can go to and point to and say, well, this is governed. All the terms and conditions as between the parties will be in that written document. Those two attorneys will negotiate, send drafts back and forth, negotiate language. 99 out of 100 times they reach an agreement. 1 out of 100 times they don't, and the deal falls apart. But they consult with their clients, they become advocates for their clients, they reach an agreement on a document, and at that point the document is signed. Now that document may or may not be signed in front of a notary public, which is completely different in America than your notary. Our notary public is there to certify that, yes, that's your signature, but beyond that notarization, that statement that, yes, that person signed in my presence and that's their purported signature, there really is no other function that they serve in the drafting of documents. So that signature occurs on the document. Now, in that document, there'll be two other references. One will be to a title company and the other will be to an escrow agent. Sometimes they're the same, sometimes they're different. A title company is a company that goes and searches the local land records in where the property is located and goes back, it could go back 60 years in the chain of title to show that there's no element in that chain of title as between buyer and seller and seller and buyer, seller and buyer, seller and buyer, for people who owned it previously, that in any way clouds the title that I'm about to purchase as the buyer. There could be a cloud on title if there was a party who didn't sign a deed, if there was a reserved mineral right, whatever it is, there's a chain of instruments that occur in the land records that the title company studies to make sure there's nothing in that chain of title that in any way jeopardizes the ownership of the property. Now, the title company will issue title insurance to the buyer and basically say, for a fee, which is an insurance fee, a one-time payment, I will ensure that you have clean title to this property when you buy it. Now that title company does that work. They issue what's known as a title commitment. The title commitment then becomes a title policy at closing. You pay your fee and you have title insurance that says you are the legal owner of that property. If you put up a deposit in the transaction, that deposit, which is generally what you would do on the signing of the contract, is placed with an escrow agent. Now, you may have a due diligence period of 30, 60, 90 days, which basically says, I can get out of this transaction if I find something I don't like about it and get my money back out of the deposit, and that's known as a due diligence period. So at closing, for example, we're doing a close, we've signed a contract about 3 weeks ago. We put up several hundreds of thousands of dollars as a deposit. We're now in our due diligence period. We're sending a notice today, electing to proceed with the transaction. We'll put up a second deposit that will stay with the escrow agent. In our situation, the title insurance has come back. The title looks clean, except for some minor things that we can clean up. And we're moving forward with the transaction. Now, once we go and place our second deposit and our due diligence period is over and we've elected to go forward, we now all move towards closing, both lawyers on both sides working together, both law firms or both lawyers working together with the title company to come up with the various adjustments that have to take place on the settlement statement of pluses and minuses. We owe them for water, they owe us for taxes, things of that nature. And we go to a closing. And at the closing, which generally used to take place face-to-face with people, but now is done more electronically in America, the seller will sign a deed, the buyer will fund the money electronically into the escrow account of the title company or the escrow agent, and then the transaction will close. And when the transaction closes, the title company takes the deed, which has been signed by the seller, notarized as to his or her signature, and they will take that to the local land records in the jurisdiction in which the land is located, and they will file that of record showing evidence that this seller, who was once a buyer, has now sold this property to a new owner. And it's that legal record that then becomes how you own real estate in America. Now that's done residentially, commercially, hotels, whatever it is, it's the same process. You sign a contract represented by attorneys. You, unless your residentials become more of a form these days, but you go forward, you have a closing, you go of record, and you're done. Now, we don't have your system of public trust in the sense that a notary in your system is someone who goes to school, maybe doesn't learn all the procedural elements to become an advocate in a court or a criminal procedure or civil procedure, but learns elements of the law such that he or she could become a person who negotiates and works out for both sides, sits in the middle and says, let's work this out and I'll draft the document. We don't have that in America. In America, it's a rare case in which we have it in America. In America, both sides are represented by counsel. Counsel and the clients negotiate the document back and forth, back and forth, back and forth. The attorney for the clients are responsible to be the advocate and the representative and to point out anything that's wrong. There is no impartial party in the middle. Both groups work together, come up with the documents, and then both groups work towards the end, towards a recordation of that document with the local jurisdiction. And that would occur if I needed a power of attorney. I would draft a power of attorney based on forms that lawyers may have in the jurisdiction, which doesn't really vary that much from jurisdiction to jurisdiction. It has some elements to it. It'll be signed in front of a notary here just to evidence that that is my signature. I did sign it in front of you, but that notary didn't help me draft it. That really came from either an attorney or a form that I had or some other process. So when you mention notaries and the importance that they play in Poland, we have no corresponding impartial individual helping draft the document for both parties. It just doesn't exist in the American system. So that's my presentation.
Thank you very much, Mr. Fuccillo. It was a very interesting presentation, really said a lot about how different the systems may be. So right now I would move the floor to all other participants. Do you have any questions to each and every of our speakers? Maybe speakers have questions to one another.
Yes, I have a question.
Yeah.
In doing my research for the presentation, I was intrigued by the history of notaries in Poland and how it's changed going back to the 13th century, and then how over time it's been abolished and then recreated and abolished and recreated. What would you say is the reason that Poland has adopted this system of this, in essence, a legally trained individual who has been placed in a position of public trust, as opposed to the American system of lawyers negotiating with each other. What is the reason that an individual has been given that responsibility in your system in its evolution?
Panie Wojtku, to rozumiem, że to pytanie do mnie kierowane.
Yes, to dla pana albo do pani Celewicz.
Tak, to jeżeli, bo nie wiem, czy Kasia słyszy, to po pierwsze trzeba tutaj panu Fuccillo jak gdyby zwrócić uwagę, że od końca XVIII wieku do 1918 roku Polska nie istniała jako państwo, tylko była podzielona pomiędzy 3 państwa i w 1918 roku dziedziczyliśmy de facto 3 różne systemy prawne, czyli system rosyjski, system pruski i system austriacki. I teraz występowały różne konkurencyjne rozwiązania, ale podobne. Dlatego, że system austriacki znał notariusza o podobnej funkcji, jak dzisiaj on jest w Polsce. System niemiecki także, zaś system rosyjski opierał się na tak zwanych pisarzach hipotecznych, którzy dokonywali wpisów w księgach wieczystych. I po odzyskaniu niepodległości w 1918 roku przez kilkanaście lat trwały dyskusje wśród prawników, który model wybrać, i wybrano model będący połączeniem doświadczeń austriackich i pruskich, gdzie notariusz staje się nie osobą prywatną, ale i nie urzędnikiem państwowym. I tak zostało do dziś. Jeżeli wskazywałem na to, że i wójt, burmistrz, prezydent miasta i minister musi przyjść do nas, przenieść własność nieruchomości, czy to jest mała osoba fizyczna, czy to jest największy magnat, który posiada tysiące hektarów, musi się pojawić u notariusza. Taką stworzono konstrukcję, gdzie uznano, że będzie to taka osoba o takim szczególnym statusie. I pierwsze rozporządzenie prezydenta Rzeczypospolitej z 1933 roku tak ukształtowało tą sytuację, która przetrwała przez kilkanaście lat. Po II wojnie światowej notariusz stał się urzędnikiem państwowym. Zlikwidowano indywidualne kancelarie notarialne. Przy sądach istniały państwowe biura notarialne, gdzie notariusz stał się urzędnikiem państwowym, a zatem był zależny od władzy. I znowu w 1991 roku, czyli po ponad 30 latach, wrócono do tego modelu notariusza jako osoby niezależnej od stron, ale i do pewnego stopnia niezależnej od państwa. Bo to nie jest tak, że nie podlegamy nadzorowi ze strony ministra sprawiedliwości. Podlegamy. Jeżeli zrobimy coś złego, jeżeli źle się zachowujemy, to minister może wszcząć postępowanie dyscyplinarne. Także nasza rola jest tutaj taka pośrednia.
Okay, so when it comes to the history of Polish notary profession, it must be noted that there were some breakthroughs. At first, from late 18th century up till 1918, there was no Poland on the maps of the world. We were divided into 3 countries, which had different solutions when it comes to real estate transfers. Both Austria and Germany, former Prussia, which used to have 2/3, like 2 parts of Poland, had a similar notary profession as we have now in Poland. The Russian model was a little different. It had the mortgage writers that are somehow different. And then when we regained our nationality and our state in 1918, there was a huge discussion up to 1930s on which model we should choose. And then we chose something which was the closest to the Austrian and German model of notaries, which are somehow independent both from the state and from the parties. So there were like individual entrepreneurs having an impartial position against the parties. Then after the World War II, with the rise of communism in Poland, those individual entrepreneurship was cancelled, and the notary profession was moved into the public sphere. So then the national notary offices were established next to the courts, and the notaries became public officials. It ended up in 1991 when they became individual entrepreneurs again. It's not like this that there is no public jurisdiction above them. We are as notaries are somehow dependent from the Ministry of Justice, who, when we do something wrong, may initiate a disciplinary proceeding against us, but still there is a big dose of, it cannot be named that we are public officials, like in the sense of public authority. So that's it. Yep, Ms. Celewicz, would you like to add anything?
Yes, I would like to add something that notarianship, like in Poland, is common for all Roman law tradition countries, and even the origin of notary, like nowadays we have notaries in Roman law countries are in Greek, because there was someone needed who can write, draft contracts, draft legal documents, because people could not write at this time. And this notary function developed for years, and now in almost, I think in every Roman law country, you can find notary with similar function like in Poland.
Yeah, thank you, Ms. Celewicz. May I also have a question? So yeah, I would have a question to, I can see Ms. Agnieszka Góra having a question. Agnieszka, take the floor and ask it.
Please go ahead, Wojtek. Sorry, I didn't.
No, you're from the audience, so feel free to. No.
Okay, so thank you very much for super interesting presentations. So I come from Poland, from this very background, and having myself finished a notarial bar training last year. However, I don't have my practice yet because I'm now in a PhD studies. So I have a couple of questions that are somehow connected with more of ground rules for the transactions of land in the States, and some other that are kind of like very technical. My first question would be, because in Poland, what happens is that somehow notaries are also the guardians of the conduct of legal transactions. So we are bound, notaries are bound to deny a transaction if they trace the sign of illegality. In a way that the biggest aspect is also testing whether a particular purchase of land can happen. For example, in Poland, there are some limitations on the purchase of agricultural land, and only certain entities under very particular circumstances can buy certain areas of land. So in that regard, it is on the notaries to ensure that such transactions don't happen. And if they happen, they meet the necessary requirements imposed by the state. My question is, how about the states? Is there any kind of a category of transactions that regard the real estate that are illegal, or that there are some limits to who can purchase or what type of land can be purchased? And if so, who is the guardian of a legality of the turnover of the ownership of the land?
I think that's a great question. It's a great question because it's so strange to me. In America, I don't know of any property that I can't buy. Now, I can't buy something that's owned by, I apologize. I could buy property owned by the government if they're selling it. There's no agricultural property that I couldn't buy. There's no industrial property. There's no real estate or residential or any property. There's no prohibition in America from my purchase of a piece of property that a willing seller who is vested in title to that property wants to part with and sell to me, even if it's agriculture or it's land. Now, it's incumbent. Now, you mentioned illegality. In America, there is nobody I turn to determine the illegality of the sale. other than myself as the person buying it or the attorney who represents me in the transaction. It could be that the person selling it to me is defrauding me in some way, or knows an element about that property that it's contaminated. And I failed to put a representation or warranty in the property that it protects me, or I have a limitation on the liability for their having breached that representation and warranty. But all of that is as between me and the other person. And if we have a disagreement, we end up going to court to work it out in America. There's nobody, there's no watchdog or anyone other than the person I retain to be my attorney and myself and my own reading and my own investigation that protects my interest at all. And there's nothing I can't buy, assuming the party owns it. You know, in America, there's an old expression, you can buy the Brooklyn Bridge, but nobody owns the Brooklyn Bridge, and no, it's not for sale. So as long as they own it and they want to sell it to me, there's no prohibition and there's nobody protecting my interest. It's just not felt to be necessary in America, I guess. I mean, the parties just deal with each other. It's fascinating. Now, I don't know in Poland and the other Roman countries whether there's a continuum of history relative to each parcel of land. But in America, you in theory can go back hundreds of years on each parcel of land and find the records. Like I just did a piece of property that went back over 100 years, back into the 1890s, because there are records that we have. Now, maybe in Poland or other countries, there are no records, and we need this protection to make sure that someone's not being swindled. But I don't know. That's why I asked the question before. But there's nothing in America I can't buy if somebody wants to sell it to me.
Thanks. And the other question, if I may have extra 5 minutes, speaking from a perspective of a practitioner, what would you say is an important clause that you seem to miss in documents coming into America that are documents from abroad? Let's say that we want to prepare a power of attorney here in Poland for the purposes of use in the States. So what would be your recommendation or maybe advice to put as a clause from a practical standpoint that is oftentimes missing because we may just simply not be aware that this might be needed?
Well, that's a great question. I apologize for not being proficient enough to answer it because I don't get that many documents from overseas. I will tell you that in America, even American attorneys will check with local counsel in a various state before we do something. Like, for example, we're closing on a transaction in the state of Florida. I'm using a District of Columbia law firm, Washington, D.C. law firm. I'm in Maryland, but we hired local counsel in the East Coast of Florida to review the contract before we signed it to see if there were any local rules and regulations that were missing from this larger form contract. And in fact, there were a couple of provisions on the sale of residential property, multifamily, that required that it not be used as condominiums for 5 years. Well, we had not put that provision in because we weren't aware of it, but they, being local counsel, knew that all real estate transactions involving multifamily residential had to have a 5-year. So all I would say to you is I don't know that there's any particular one clause that's missing or whatever, but wherever you're doing work, just check with local counsel. Is there anything about this document in your jurisdiction? Like, for example, one time I did a promissory note that was a self-effectuating promissory note that did not really require any further notice to the debtor other than just recording the note as a lien against their property. There were certain provisions in there that were missing that required me to wait 30 days, those kinds of nuances. So yes, there are nuances in the States. It's worth checking. It's just a phone call, and don't ever be embarrassed without asking. Don't ever be embarrassed. Always ask.
Hope not to confuse the time zones. Thank you very much for this answer.
Thank you very much for your questions, Agnieszka. And right now we can see a question from Ms. Justyna Glinka. Justyna, take the floor.
Hi, hello. Am I visible?
Yeah.
Can you hear me? Yes. Okay, so I also got a question which is connected with Mr. Fuccillo speech. I'm supporting real estate transactions in Poland. So what was interesting to me in your speech that you mentioned insurance of the transaction and the institution of the escrow agent and the title insurer. So my question is whether the title insurance in your jurisdiction is something which is obligatory for the transaction to be effected, or this is just a facultative element to which the parties to the transaction may decide because of being aware that there are some deficiencies of the title, for example, and they want to secure it. Because this is how it works today in Poland, that, for example, if the parties to the transaction see that there is something wrong with title to the property, of course, they can go to the insurer. And for example, for thousands of euro, they might buy such title insurance to secure the transaction, but it's not obligatory. And you do not need to have the escrow agent. You do not need to have the notarial deposit, for example. Yes. So my question is whether in United States you can just sign the contract, have no title insurance, no escrow agent, and have the risk on your own as the buyer that you buy such title to the property. Thank you very much.
Yeah, excellent question. Excellent question. So here's the reality of that. Here's the reality of that answer. Let me take them in two separate parts. If I'm entering a major transaction and it involves, like, for example, the transaction we're doing in Florida, $65 million. So we're buying a multifamily project in Florida for $65 million. The seller wants to know that we have money to undertake the transaction. So they will require a deposit. Now, the deposit is, in this situation, 1%. So we gave them $650,000 at the signing of the contract, and we will be giving them another $650,000 when we go hard, it's called, at the end of the due diligence period. I would never give that money to the seller to hold. I wouldn't trust that the seller is going to be there in the end to apply it to my purchase price. I would only give that money to an impartial escrow agent who has entered into the transaction simply to hold the money for both parties and to apply that money at the end in accordance with the terms and conditions of the contract. For example, if the seller defaults and fails to give me the deed or comply with the terms and conditions of the contract, I want my $650,000 back. The escrow agent would then return that money to me based on the terms and conditions of the contract. Likewise, if I fail to show up at closing with the balance of the money, in America, the only money that the party gets is my deposit. In America, you cannot sue the party who's buying for the rest of the money. You cannot, in America, force a buyer to put up the balance of the funds. You can't force a buyer to buy under the law in almost every state in America. I can force a seller to sell. If the seller refuses to deliver the deed, I can sue on that contract, and I can sue for what's known as specific performance. In essence, say to a court, please force the seller to deliver the deed. The courts will enforce that and require the seller to deliver the deed, but they won't force a buyer to buy because that involves money. So when it comes to escrow, I would never give my escrow down payment to the seller, only to an escrow agent. Is an escrow required? No. If the seller didn't want to know that I had the money, the seller didn't care, the seller just did a contract and said, come to closing, I am not required to put up an escrow under law, and there would be no escrow. When it comes to title insurance, it is a little bit of a pet issue that I've had over the years, is it's not necessary in America to get title insurance, but everybody's chicken, everybody's scared. Nobody in America seems to just say, well, this property has been around, it seems to be okay. There's no reason to get title insurance. Why should I spend $130,000 to go insure this title? But nobody in America does that. Well, I say nobody. There's one or two people who do it, but everybody gets title insurance out of the utmost of caution and fear that they're going to lose their investment. It is somewhat nuts, I'll admit, and it's not required in America, but people do it out of force of habit.
Thank you very much for this question and answer. Are there any other questions that any of you would like to ask?
May I just have a comment, sorry, to follow up on Justina's inquiry and the title insurance.
Okay.
It seems to be very interesting. Please clarify, what is the due diligence applicable to? Is it the legal state of property, or it's or it is also the factual kind of liking or not liking? Because what's interesting to hear is that for the very first time, I actually noticed that majority of the aspects that you mentioned within the due diligence are concluded before actually the contract is signed in front of a notary, because all the necessary documents, all the representations and warranties, they need to be stated in the contract. So typically it is not possible to back up from a contract simply saying, of course, asterisk various clauses. That is how it is different, and in that way, again, notaries are kind of guardians to the transaction. So in that saying, there is also no making people pay money up front if they don't know the legal state of the property in advance, because when the contract happens, it is clear that the situation is clear and secure, and only after that or before that the payment happens. That is why this insurance is not at all popular, I would say. Or maybe there are some different comments. I would love to hear other perspectives.
Yeah, another great question. Right, this is very interesting. Let's use the transaction that we're doing in Florida as an example. And let's use a transaction. Let's make it any price. Make it 5 million, make it 10 million, make it 65 million, make it 100 million. We just did a transaction 250 million. When we negotiate the letter of intent and we take it to a contract, the provisions of that contract, are many and varied. There's an awful lot of reps and warranties. There are a lot of provisions on how that person's to maintain that property during our pre-closing period. There are provisions and representations and warranties on the buyer's part. There's procedures, there's deposits, there's all sorts of things. But one of the things that we never know, really, when we are buying a property, is the condition of that property such that we are happy to buy it. So when we negotiate a letter of intent, it's because the seller wants to sell it and we're the buyer, we want to buy it. And these are the terms and conditions, generally speaking, terms and conditions, broader terms and conditions in the letter of intent, maybe 3 pages long. Contract may be 50 pages long. We then take those terms and conditions and we put them in a contract. And we in America, you will be expected to put up an escrow deposit in good faith. And here's why. I'll tell you, I got 2 ways to answer your question. 2 points to answer in your question. The reason you put up an escrow deposit is I've spent, in theory, 60 days negotiating a letter of intent. So let's say. I then spend another 60 days negotiating the contract. So I've now invested essentially, a long period of time, 120 days on you, who's the buyer. So what I want you to do is I'd like you to put up some good faith deposit to bind the contract, but I will give you 60 days, 90 days to explore the environmental condition of the property, the soil condition of the property, all the leases on the property, the structural elements of the property, the roof, the relationship with the local government, Whether you owe any money, I will check the taxes on the property. I will check the title on the property. I will do a resurvey of the property. In other words, I am going to check 30 things about your property, better than you even know it, so that I know that the survey is correct, there are no encroachments, there are no prior liens, no mortgages, that it was built structurally correct, that the footings are correct, it was built in accordance with the plans, there are no governmental violations, the roof doesn't leak, all the leases are in place, the income you promised me is in place. I will take that entire 60 days, 90 days, and I call it my due diligence period. That's the period in which I determine in my sole and absolute discretion, in that 60 or 90-day period or 30-day period, whatever we've negotiated, whether we're going to do the transaction. And then I notify you that the transaction can go forward, and I don't want my money back, and put my money towards the purchase price. But if I notify you the deal's off, it's because in my sole discretion, I found something I didn't like. That's the way it works in America. Once you sign a contract, doesn't mean it's over. You can still get out in most major transactions, in all major transactions. Even in residential in America, you generally get 10 days, 5 days to do a house inspection to make sure the house doesn't have mold or sinking or water problems or roof leaks. So we are not absolute. Clearly, when you sign a contract, you do get provisions and protections post the signing, if that answers your question.
In full, thanks.
Thank you very much. So are there any other questions? As we have already come to the end of our webinar. I see no further questions. Therefore, thank you very much, Ms. Celewicz. Thank you very much, Mr. Fuccillo. Thank you very much, Mr. Maj, for your time. Thank you for explaining all the essence and also so many details out of your professional practice about the notary practice and real estate lawyer practice. We got to know quite a lot about it, and I'm very happy that I was given the possibility to have you here to host this meeting. So thank you very much. It was a great pleasure, and I'm looking forward to your participation in another webinars. We're seeing in a week, next Thursday, there will be a meeting about the alternative dispute resolution system. So thank you very much, and I look forward to see you again.
Dziękuję bardzo. Dziękuję za zaproszenie. Do usłyszenia, do zobaczenia.
Thank you very much, Mr. Maj.
Thank you very much. My pleasure.
Thank you.
Thank you very much.
Thank you very much, Mr. Celewicz. And also, if any one of you have still some questions about the American Law Program, about other Catholic University of America and Legal University undertakings, also feel free to ask. I stopped the recording right now.